Thanks for coming to listen to me. This has been really cool. I really enjoyed meeting everybody today. One of the things that's really fun when I go to conferences like this is one, getting to see the vendors who I've gotten to know. And then the other thing is when I get to see people who say, hey, you did my, and fill in the blank, I've done something for them, and that's always exciting for me. I'm really thrilled to have a chance to be here today. I have really a passion for education, and I think that there are lots of things that you all need to know. I do have a planned presentation and slides. My background is a non-traditional lawyer, so I have lots of different things in my background. I have lots of people in my background who are in my family circle that have disabilities. So I live in this world as well as work in this world. And this lovely young woman here in the blue and gray striped hat is Bethany Jeffries. She runs my office and most of the rest of my life. She won't mind me telling you, if you've all met her today, she's also has autism, very high functioning, obviously. She's getting ready to finish her degree at Iowa State University and is in the top 7.5% of her class, if I can brag on her. Just got accepted into that honor society. And is headed for law school when she finishes her undergrad degree. So I'm very excited about that. I'm presuming that she comes back and hangs out with me, which I think that's her plan. So we're gonna talk about substitute decision making today, and I'm gonna try to kind of zip through things fairly quickly because I really wanna save time at the end for questions. And if we want to, I've gotten lots of questions today about special needs planning, and so that means like how do I plan for, you know, leaving an inheritance for one of my children that has a disability without disrupting their government benefits. And so when we're at the end, we can take questions related to that also. All right, Bethany's gonna be my remote control. Alrighty, so back up a minute to the last slide. Overview. We're going to talk about definitions and roles, different types of powers of attorney, what is a conservatorship, and then we're not going to spend a lot of time on conservatorships. This is more going to focus on the guardianship, what, when, why, how, and how much. How do we get a guardianship? And so we're going to first talk about some terms. Pardon me, principal. Principal is the person who signs a document. The agent, the person who has been granted some authority under a document. People say all the time, I'm power of attorney. You're not power of attorney, you're agent. Power of attorney is the document. Or people tell me all the time, well, I'm the executor. You're not an executor till somebody has died and the court has tapped you on the shoulder with his magic sword and said, you are the executor, yeah. So you have no legal authority as an executor till somebody has died and the court has said, okay, you get to be it. Fiduciary is lots of people. A fiduciary is a person who has a responsibility to put somebody else's needs ahead of their own and not take advantage of their situation. That's the layman's definition of fiduciary. Generally, it involves money, so you're in charge of somebody else's money, but it is also just generally the idea that you can't take advantage of your position of authority or influence. And then power of attorney, that's the document that grants somebody the authority to do something on behalf of someone else. Respondent. So we've changed the words in the guardianship world. In 2020, there were sweeping changes of the guardianship and conservatorship statutes. We used to call somebody who was the person under a guardianship or conservatorship a ward, and now the terminology has changed. And until a court says, yes, you have to have a guardianship, you are a respondent. So that's the terminology there. And then once the judge has said, yes, you really do, this person's gonna be in charge of you now, then you become a protected person. So that's where the terminology changes. A guardian is the person who is granted legal authority by the court to make decisions for you. Now, there is a natural guardian, which is a parent. A parent is a natural guardian. But once you turn 18, that doesn't work anymore. And so then if you still need somebody to have that type of legal authority, then that's the legal guardian. A conservator, so the guardian decides, where am I going to live? Am I going to go to the doctor? Do I go to school? Do I, how am I going to run my life? A conservator is in charge of the money. So the money. And so if your only source of income is Social Security, and somebody is your representative payee for Social Security, and you don't have any assets, then you don't need a conservator. So a conservator handles the money. Next page. Oh, she's ahead. Pardon? Yes, that was the thing. And I would like to point out that guardianship and conservatorship laws are very much state creatures. And the terminology is not the same across the entire country. In Texas, a guardian is in charge of the money, and a conservator is in charge of the person. So, this is Iowa terminology, Iowa specific, that we're talking about today. So there are two different kinds of powers of attorney. So do we need a guardianship? Can we get a power of attorney? How do we figure out the difference there? And the statute, the law in Iowa is that least restrictive. So the judge, if you're in front of a judge, the judge has to determine what is the least restrictive means of managing the needs of this person. And so they first look at powers of attorney. So a power of attorney, there are two kinds. There's a healthcare power of attorney, and that gives somebody the legal authority to make medical decisions for you after a doctor has said you cannot make medical decisions for yourself anymore. So that is not effective until a doctor has said this person can't make their own medical decisions anymore. A general durable power of attorney is for everything that's not a medical decision. So it could be for, we think of it as a financial power of attorney, but it's also for signing contracts, changing mailing addresses, taking your pet to the vet to get a vaccination, all kinds of other things. And a power of attorney can be effective right now, or you can put something in there that says it's not effective unless and until this thing happens. So for example, powers of attorney very routinely in the past would say, this is not effective unless a doctor says I can't make my own decisions anymore. That's kind of the opposite now that, things evolve and change, and the opposite now is true, where most powers of attorney that you sign are effective now. And either a healthcare power of attorney or a general durable power of attorney, those can be revoked at any time, even after a doctor has said you can't make your own medical decisions anymore, or you can't make your own decisions anymore. And the problem you have when your power of attorney is revoked, if you really needed somebody to be doing things for you, is now there's nobody who has any authority. So sometimes it can be the right tool, but it not always is the right tool. Bethany, go on to the next. Healthcare power of attorney questions. Who should serve as your agent? That's something that the person who's signing the document gets to say. So as the parent, you don't get to say, I'm going to be his agent. He has to tell me, I want my mom to be my agent. He's still, until that person's, somebody's taking that decision-making authority away from that person is still the one who's calling the shots and making the decisions. Can you have more than one agent? And the answer legally is yes. From a practical standpoint, then we have the discussion, is this a wise thing to do? So for people who have, let's say that you have your kiddo has turned 18 years old, you're trying to get a power of attorney, you have a intact family and everybody gets along and mom and dad both do things, then maybe co-agents is a good idea. We have a not intact family, and people don't always see eye to eye on the same things, then having two agents, even with independent authority to act, is kind of a problem. So our general advice is one agent at a time. And then how long is it good for? It's good forever until you revoke it. So there's not a expiration date on a power of attorney. Okay, I jumped ahead of myself. Can I use it to force someone to get medical care? No, it's revocable. So the person who has signed it, they can say, no, I don't want to do that. Now, lots of times I'm dealing in the elder law arena. So the question is, can I use my power of attorney to take my mother to a nursing home? And the answer is, well, legally, no. But then you're reeling mom into the nursing home, and she's going, you can't do this. You can't make me move here. You don't have any authority to do that. And what do? We stick our fingers in our ears and we go, la, 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 I didn't hear anything. Because literally, that's a revocation of the power of attorney, and the alternative then is we're at court getting a guardianship. So, we do have statutory powers of attorney forms. That means they're built into our law. And if you Google the Iowa power of attorney, you can find the form built right into the law. Do not do this at home. It is not a good form. The healthcare power of attorney form isn't as bad as the general durable power of attorney form. But you can find all kinds of forms online, and the bar forms, you know, AARP now has made the bar forms available through their website too. You're gonna have some inside information now about how the attorney world works. We have a really good bar association in Iowa. I'm a member of 3 bar associations, and Iowa's is really good. We have lots of advocates. We pay a lot of attention to what's happening about how laws are written, and we have a forms committee, and that means that attorneys, we don't just reinvent things so that they're not uniform across the state generally. So there are sections of the bar association for different areas of practice, and the guardianship stuff falls under the probate area of practice. That's Iowa Code 633. The powers of attorneys, they have their own different statutes. The healthcare power of attorney statute, I think, is 140 something, 146B, I'm not sure. And the general durable power of attorney, it says, I think, 633. Well, I don't have the numbers in my head. Anyways, you could Google that and find it, and find the form. And so the probate section, we have a committee, a forms committee. And somebody said, hey, we should have one standard power of attorney form for all the attorneys who are practicing in Iowa to use. And so they made a committee, and the committee designed the form. And the committee who designed the form primarily had older people in mind. It was an elder law issue for them. And they determined that if you are using a power of attorney to make decisions for someone else, you're probably trying to steal from them. So they made it a very conservative form. And there are things that you can do under the statute with the power of attorney that they didn't put on the form. And there are things that you can do as an agent under power of attorney only if it's on the form, and they didn't put it on the form. And so my suggestion is don't use that one. When you get a power of attorney, if you call an attorney, don't do it yourself. Don't do online, no. And then if you are getting a power of attorney from an attorney, ask them, do they use the bar form? There's the magic phrase. Do you use the bar form? And if their answer is yes, then you say, can you make a custom power of attorney for me that's broader than the bar form? And they might say yes, or they might say no. I don't, but that's what I would do. Alrighty, so it's very short, doesn't provide legal guidance about what options are available. The healthcare power of attorney defaults, the statutory form defaults to whoever you've named as agent. That's who gets the privacy release also. The privacy release part, that's effective now. Like who can call the doctor and make doctor's appointments, things like that. That you don't have to wait for a doctor to say you're incapacitated to give somebody else the legal authority to be in the conversation. But if you use the bar form, it will only have one person or 2 people's names on it, and those are the people you said who are your agent and your alternate agent. And you can have as many people as you want. On my power of attorney, I have like 6 people or 7 people listed on my power of attorney form. On my dad's healthcare power of attorney form, Bethany is listed as a person on there. I do things for him, she does things for me. So that's another reason to have a custom form. And then it doesn't, so you can have, this happens more in the older arena, so you know, somebody comes into my office, says mom needs, you know, I have healthcare power of attorney for mom. I don't have healthcare power of attorney for mom. Dad had healthcare power of attorney for mom. He's died, and there was nobody named next. Mom can't sign a new power of attorney. Can I, you know, be her agent? And I say no. If that other document had said that somebody could name a successor, then yes, but it didn't, so no. So we build that into our powers of attorney that whoever is currently serving as an agent, if they can't serve anymore, they can pick the next person in line. Or if we've done it, then somebody can come to us and we can pick the next person in line if we can find somebody to do it. So you don't run out of agents. That's our goal. Who can sign a power of attorney, healthcare power of attorney, or a general durable power of attorney. You have to be 18 years of age. There's nothing in the statute about capacity. There's nothing in the Iowa Code that says you have to have this level of decision-making ability to be able to have a legally binding healthcare power of attorney. So it's up to me, the lawyer, it's up to me to decide, can you sign a power of attorney or do we need a guardianship? And medical, if a doctor has said this person should not be making their own decisions anymore, does that mean that I can't decide this person can sign a power of attorney? No. Medical records, it's evidence that I should take into consideration, but it doesn't necessarily mean that the person doesn't have the capacity to do that. One of the things I am going to do is I'm going to ask to talk to that person alone. So then people, and I say, I'm going to talk to Bill alone, so you're going to go wait over here. And they go, I don't think so. I'm like, I have to know what Bill wants. Without you sitting here telling me what Bill wants, or Bill telling me what he thinks you want, because that's what he's supposed to say, or you're going to be mad. Yeah. So what constitutes termination? Oh, 144B8B is the healthcare power of attorney statute. Revoked at any time, we talked about that. The principal is presumed to have capacity to revoke it, so that's what happens. Next slide. I get ahead of myself a little bit. Alrighty, so 144B.6, the attorney, in fact, has a priority to make decisions over a guardian. What if we went and got a guardianship, but somebody had already had power of attorney? Unless the court revokes it, then that person is still in authority, so that ends up being a problem as well. Next one. 633 of the probate code. We're going to talk about guardianships now. So what if we decided that power of attorney wasn't a good idea, person can't sign it, or they're going to sign it and revoke it, sign it and revoke it, it's not going to get us where we need to go, and we think that we need a guardianship. How do we get one? It used to be that we could do a voluntary guardianship, so the person who needed a guardian could say to me, I need a guardian, I want my mom to be it. We would file something with the court that said, we need a guardianship. We would file something from a doctor that says, this person has impaired decision-making, but they have enough decision-making capacity to be able to pick their own guardian. And we would file a proposed order to the judge that says, hey, please do what we asked. And the judge would say, yep, you got it. And there would be a rubber stamp on there. Well, they don't do that anymore. So now it's the petitioner. So anybody can be a petitioner. Who can be a petitioner? You have to be an adult. But anybody can be a petitioner. Can be a parent, can be a sister, can be a cousin, can be the hospital, can be a petitioner. But in your petition, you need to say who's going to be the guardian. So you kind of have to have ducks in a row generally before you do that. The respondent, so then we have to give notice. No more secret guardianships where somebody comes in and says, Mom needs a guardian. None of the rest of the kids really have anything to do with our life. Mom's going, yeah, that's right. Judy lives with me. She's going to take care of me. I want her to be it. And we get a guardianship, and none of the rest of the siblings know about it till after everything's said and done. And they're like, hey, wait, Judy's kids are coming over on the weekends and eating Grandma's food. And then you have an argument. So now everybody gets notice. The respondent, if the respondent has a spouse, the spouse gets notice. Adult children, if they have parents that are still alive, they get notice. Anyone who's had power of attorney, anyone who's a representative payee of Social Security, anyone with whom the respondent has lived for 6 months or is living, yes. So if that person still has a living parent, we have to try to find him, give him notice. Yeah, I know. Because you can tell me, well, he's not been around, but, you know, is that true? How do I know that's true? How does the judge know that that's true? Because you know what? Everybody always tells the truth all the time. There's never that problem. All right, so that means if your child is living in a group home or someplace like that, then they're entitled to notice as well. The respondent must have an attorney. That's one of the rules now. So when we file our petition, we also ask the court to appoint an attorney. If the respondent doesn't have any money, then we can also ask that the respondent's attorney's fees come at county expense. And we must have a hearing, so no more rubber stamping. Even if everybody agrees We've got a letter from the doctor saying, yes, this young man needs a guardianship, and we've got an intact family. Both parents have signed the petition. Still, we have to go to court, and the judge has to see people in person. That was a change that happened in 2020 also. So when can you start a guardianship? A lot of people ask me this today. You can start it at 17 years and 6 months. So why is it that? What happened was, before it was not until you're 18. But a guardianship process, you have to give notice to people that this is happening, and they have to have time to respond. So if you can't give notice, and I have to give notice to you that somebody's filed a guardianship petition over you, and I have to give you time to go, hey, wait, I don't want that. And so we'd have this gap of time period between when notice was served and when the hearing was actually held, where nobody could make any decisions for that person, and that was causing a problem. So they backed it up. I can serve notice now at 17 years and 6 months on the respondent that this is happening. Both parents have legal rights unless the legal rights have been terminated. So if you've had a termination of parental rights before they're 18 years old, then that can cut that off. Other than that, nope, everybody has legal rights. And then I think I covered all of that. Okay, next slide. What do you have to prove? This is the statute, that the person's decision-making capacity is so impaired that the person is unable to care for the person's personal safety or to attend to or provide for necessities for the person, such as food, shelter, clothing, or medical care, without which physical injury or illness may occur. That's our burden of proof. So guardianships used to be pretty much all or nothing. Once you got to be guardian over somebody, you were the boss. And we had a case in the 1990s. This was a case. It was a young man with an intellectual disability. His last name was Hadeen. We call it the Hadeen case. And he wanted to get married. And his sister was his guardian, and she said no. And so he filed a lawsuit filed an appeal, and it went all the way to the Iowa Supreme Court, where they said, you're right. It's not all or nothing. We shouldn't take all the rights away from somebody just because they have impaired decision-making. So the judge is required to make a determination of how limited a guardianship should be. And in the statute, it says, such as, should they retain the right to vote? Or should they retain the right to change their marital status? And it didn't go much further than that, other than just saying, such as these things. Now, and so it depends on the judge and the attorneys that are involved in this, how much you want to go down the road. For me, well, it depends on what you're dealing with. Like if you're dealing with an older person who's in a nursing home, the things you're asking for are a little bit different than if you're dealing with somebody who's 18 or 19 years old with an intellectual disability and has a Facebook account and maybe wants to drive, is working part-time. Then we talk about, what are the limitations? Can I decide what decisions do I get to keep for myself? Do I get to have social media accounts without oversight, or am I required to give my passwords to my guardian? Different questions like that just we never even thought about thinking about before, because there's so many different opportunities now that can get us into trouble, or where people can take advantage of us. And but we do go down that, and we talk about and so that's what your attorney should be asking you. And the attorney for the protected person or the respondent, their job is not to tell the court what's in the best interest of the respondent. Their job is to be the respondent's mouthpiece. What do they want? That's their job. And so that gets to be problematic when you're the attorney who's been appointed to represent somebody who has a diminished capacity, and they don't want a guardianship, or they want to keep the right to do things that they really should not. So as an attorney, I have two jobs. One is be a zealous advocate for my client, and the other one is to not let my client shoot themselves in the foot. So what do I do? Yes. Right, and so, and I get it. You're like, he can make. So what you're really saying to me is, my child can make good decisions as long as I'm there to guide him in the decisions that he's making. But if he's left independent to evaluate information on his own and make a judgment as to whether or not this would be a good thing to do, he doesn't really have that capability. And so that is grounds for guardianship, yeah. And so what do you do if you have a client who does not want a guardianship, but you're the attorney and you know they need one? So that's when we get a court, I don't know if I have a slide on this, but that's when we invite a court visitor. So we ask the court to appoint a court visitor, which is a third attorney. And that attorney's job is to be a neutral third person, does an independent evaluation, looks at the medical records, looks at the visits with the person who's supposed to be the guardian, talks to the person who's the subject of the proceedings, and then lets the court know, do they think that a guardianship is the right thing, and is the person who's being proposed as the guardian the right person? Do we have the right people on the right seats of the bus? And should there be a limitation, and if so, what the limitation should be? And that report carries a lot of weight with the court. So it's almost like a guardian ad litem. They used to call it a guardian ad litem. They changed the terminology, and now it's called a court visitor. Okay, and generally, the question, when I do this, the question of can the person vote or not vote, that question is usually answered by the person who's there, the petitioner, whoever's supposed to be the guardian has to be at the hearing, and whatever their opinion is, that's generally what the judge does. The person who is the subject of all of this, they have a right to be in the courtroom, but many times they're not. And so if they want to keep these rights, they need to be there and say, hey, I still want to keep my right to vote. Most of the time, the judges will say, well, you can't change your marital status without court approval. That's just kind of blanket the way they do it. Next slide. How do we get one? So first, we have this wonderful system now called EDMS. It's the Electronic Document Management System, and that's how the court manages all of the paperwork. We used to take our papers down to the courthouse, to the clerk's office, and put a stamp on them. We don't do that anymore. They don't want paper. So in order to do things, you have to have an account, an EDMS account established to start with, and then you prepare your petition for guardianship. So that's a petition that says, here's the person who has a problem, here's some information about why they have a problem, here's where they live, here's the people involved, here's the people who we think meet the statutory definition of needing notice, and we want a hearing on this to see if we can get a guardianship for this person. You have to have a background check now to be a guardian. Didn't used to be that way, but now you have to fill out this form, and it costs $15, and the judge sees the results, we don't, and there is nothing in the statute that says who can and how do you pass a background report, how do you pass a background check. That's totally up to the judge. So if the judge decides that you passed it, then you did. We need some kind of medical record. Generally, we can get some kind of medical record that supports the need for a guardianship. There is a piece in the statute, if you don't have access to medical records and the person who is the subject of this is not telling the doctor, yes, it's okay to give my medical records to my mom or my dad, there is something in the statute that requires the judge can require the person to get an evaluation, and that has to be done by a person that's qualified, and the statute says who's qualified. It doesn't necessarily have to be a doctor, but it has to be somebody who has a background in making these types of mental health evaluations. And then we submit our proposed order for a hearing, which is different depending on what county you're in. So Polk County is the only county that has a dedicated probate judge. Judge Raines is the probate county judge. All the rest of the counties in Iowa, whatever judge does family law and criminal law and everything else, does the probate there also. Most of the counties in Iowa now, they've really cut the funding for those, so they're not open there's not a judge there all the time. So they will assign you your court date on court service day. And in Polk County, if you're doing this yourself, you can, or what we do is we call or email Jennifer, who is Judge Raines' clerk. We ask for court date, she puts it on the docket, and we put that court date in our proposed order to start with. Then, step 2, we have to send notice to all those people who we said. So we send, and we have to send notice to the respondent. Now they've changed this recently because, you know, if the sheriff shows up at your house and says, can I talk to Billy? You know, maybe Billy's gonna get upset. And the same thing on the other end of the spectrum when we're dealing with older people with dementia, you know, and then somebody shows up. So the statute does now allow us to send notice to the attorney that's been appointed to represent that person. And so that's generally what we'll do. Usually we'll call that attorney and say, will you accept service on behalf of this? And they will, and they'll sign some forms. They'll file a document that says, hey, we got notice, everything's okay. But for everybody else, then we have to send them a notice that says there was a petition filed and there's going to be a hearing, and if you want to be involved, you have to contact the clerk of court. And then we have to prove that we sent the notice. So then we have to fill out this thing that says, hey, we sent notice to all these other people, and file that. That's our affidavit of notice or an affidavit of mailing. So now what happens? The respondent's entitled to a lawyer, so the court enters the order that says when your hearing is and who the attorney is that's going to represent the other person. And then the other person's job, the opposing counsel's job, is to file an answer. Pardon me. And the answer says, yes, we agree, or no, we don't agree. Either yes, we agree with the petition, but we don't agree with who's going to be the guardian, or yes, we agree with the petition, and yes, we agree with the guardian, or no, we don't agree with the petition at all, and we don't want a guardianship. And and as we talked about before, it's their job to advocate for what the person wants. That means somebody's going to call you and say, can I talk to Billy? And can I come over and talk to Billy? And you have to say yes. So the respondent is entitled to their attorney. They don't have to come to your house. Billy can go to their office, but you cannot interfere with that attorney-client relationship. When we do it, lots of times, there are certain attorneys that work a lot in this arena. And it's nice when I'm working with an attorney on the other side of the table who I know does a lot of this work, and who I know knows that thing I just told you about. If my client doesn't want something they need, I should ask the court for a court visitor. Because what you don't want to run into is one of those attorneys who doesn't do a lot of this kind of work, and they know they need to be a zealous advocate for their client, and their client does not want this, and they're going to fight tooth and nail and get another medical evaluation, and you know, you really want, because that gets expensive. You know, it's just really for not any good purpose. So I like it when I'm working with somebody. There are attorneys who will not do that. So I'll call an attorney. I'll say, hey, I got a new guardianship case. Do you have a time to be a guardian for this or that person? It's probably going to be at county expense, which means you're not going to make very much money. And you like to know that in advance too, because if the court appoints somebody who isn't willing to do it, you can't. There's a limit to how much dollars per hour you can make as get paid under the county. And there are lots of attorneys that won't do it. And so if the court appoints you and that person won't do it, then you get another order from the court saying, oh wait, that attorney said no, and then they appoint somebody else. So it's better just to find somebody in advance. But there are old school judges who don't like us doing that. They think it looks like we're collaborating too much. And it's a conflict of interest. And I've had judges who would not appoint the attorney who had said, yes, I'll do it, for no other reason than I suggested her. So, you know, it depends on what county you're in, and also what generation the judge is in, because things change. So court visitor, that's that neutral third party that we were talking about already. Okay, so now we're at our hearing. You get your hearing. The guardian has to be at the courthouse. You cannot not go. So if you can't go, then you're not going to be able to be the guardian. You have to go. The attorneys, they have to go. And the respondent has a right to be in the courtroom. And it rarely happens that they come, but they have a right to be there. And if they're not there, then their presence has to be waived on the record. Excuse me just a second. How am I doing on time? You talked for half an hour. Okay. Part of what I'm doing here is giving you step by step, like how do you do this? Because I think that you should be able to do it yourselves if it's not contested. So if there's not any disagreement over the fact that a guardianship is needed, you've got medical records, the respondent is saying, yes, I still want mom and dad to be making decisions for me, and mom and dad are not arguing over who's going to be if we're both going to be guardians, you can both be guardians, or if only one of us is going to be it, which one it is, then can you do this yourself? And I have written a do-it-yourself, step-by-step book with fill-in-the-blank forms that I'm trying to figure out how to make available to people. But this presentation is intended to go along with that book of how do you do that yourself. So that's why we're going through this in so much detail. And so then you have to go to the courthouse. You figure out where you're going, you get to the courthouse early, you're letting the clerk of court know that you're there, and then it's your turn for the hearing. And you have documents like our medical records that we've supported, that's evidence. So when we upload our medical report to EDMS, we call it a proposed exhibit. And then at the hearing, we talk about this medical report. Once we've talked about it, that's called laying a foundation for our document, then we ask the court to admit that as evidence, and then that becomes part of the record once that happens. The testimony, there, you can bring people with you. You need to bring people with you who know what's going on. So, you know, somebody who doesn't know anything firsthand and knows what somebody else told them, that doesn't do you any good. Y'all have heard that hearsay. That's hearsay. You know, what that means is you don't have any firsthand experience of this. But you can bring people along, if there are adult siblings, somebody else who's very close to this person and knows that this is the right person to do this for the respondent. In these type of cases, what would be the most valuable to you? Why would you bring somebody else with you? And that would be if there are things, rights, that the respondent wants to keep. And they need somebody there to tell the judge that this person really has the ability to keep this right, and here's ways they've exercised it responsibly in the past, and why they should keep the right to do this. Maybe it's the right to vote. So that would be when it would be important to provide the judge, because the judge needs to make sure they can only make a decision based on evidence that is there in front of them. And so what the judge has to figure out is, do we need a guardianship at all? If we do need one, how should it be limited? And who should be appointed as guardian? And then does the guardian have to post a bond? So bond is like an insurance policy that protects the protected person from the guardian running away with their money. Now, I told you before, we don't need a guardianship, a conservatorship if there's not any money. But the guardian is in charge of personal property. So if you have somebody who does have some valuable personal property, maybe an expensive car, could be in some or more well-to-do families, there could be some very expensive personal property, and in that case, the judge could order that the guardian post a bond. It's not very common, but it can happen. And then the judge also has to figure out, well, why are you only asking for a guardianship? Do we need a conservatorship? So you have to tell the judge what the money situation and asset situation is, so that the judge knows whether or not a conservatorship is needed. And I've had cases where I've asked for a conservatorship and the judge said, no, you don't need one. So, okay. So the judge then, once you're at the end, the judge will tell you at the hearing whether you won or you didn't win. It's not one of those things where you don't know the answer and you leave the courthouse and wait to find out. The judge will tell you, yes, I'm going to grant the petition, this person is going to be the guardian. And, but then the judge will enter an order. So the order is the written piece of paper that says who's the guardian, what's their authority. And that's what you have to wait for. Once you get your order, then you also have to get your letter of appointment. So the order by itself doesn't give you any authority to do anything, even though the judge has said, you are the guardian for Billy. You're not able to do anything until you get the letter of appointment from the court. In order to get the letter of appointment from the court, you have to file an oath. The oath says, I promise to do what I'm supposed to do, and if there was a bond requirement, you have to get your bond posted first before you can get your letter of appointment. So your letter of appointment and your order, we call that the magic package. So then when you need to do something, you need to use your authority. Those are the two things that you show whoever it is you're trying to convince that you have legal authority to make decisions. And then, but at that point, you only have real basic authority. So the next step after you've been appointed as a guardian is you have to file your initial guardianship care plan. And that has to be filed within 60 days of your letter of appointment. So the guardian's initial care plan deals with all kinds of issues. Where is this person going to live? What kind of medical care are they needing? What kind of vocational services are they needing? What kind of social interactions are you going to facilitate? What kind of family interactions are you going to facilitate? You don't get to decide who the protected person is going to have relationships with now. There are protections now built into the statute that says you cannot interfere with established relationships that the protected person already has unless you get court authority to do that. Which was a big thing, because what would happen is one person gets a guardianship and now they're the gatekeeper, and it's kind of like prison for the other person, and you've got all these people complaining, you know, I can't see Billy anymore, and there's nothing they can do about it unless they hire a lawyer. Pardon? Yes, it can be very isolating, right. So it says who lives where. There is a form. The Iowa Supreme Court has invented, they created all of these forms for many reports that you have to use in the guardianship and conservatorship arena, and they are available on the Iowa Supreme Court website. Not all the forms you need, but some of them. The annual reporting form, so this form that you need and the annual reporting form are on there. Now, I think the forms are a little overkill in the information that they ask for, because the information that the statute says you have to require is this, and the forms ask you this. But I mean, it's better overkill than underkill, I think, probably. At least you're thinking about all these things. Basically what it is it makes you think about all the things you really should be thinking about anyway if you're in charge of somebody else. And so if you can fill that form out. There's a deadline by when it has to be filed, and then there's a waiting period before the judge will send you an order saying, okay, you're allowed to do this. And if there's something that you're really wanting to do during the next year that's a little outside the normal, then go ahead and ask for permission and say that you need to do that in your initial plan. And that way, when it pops up later on in the year, you don't have to go back to the court and ask the court for permission to be able to do it. So the conservator, there's also, if you're a conservator, there's also a form the conservator has to fill out, but that form, they have to send it to some other people, and other people are required to get notice of what you plan to spend the money on, and they have a time to object to that also. Alrighty, so what do you have to get special permission for? You have to get special permission to change a protected person's residence to a more restrictive environment. So that means if Billy's home and he's going to need to go to a group home, then that's a more restrictive environment. It also means if Billy's home and he's going to need to go to the psychiatric hospital for a little while, what about that? And so we have folks who have kids who have some fairly significant mental health issues, schizophrenia, bipolar disorder, and their meds get messed up, or they don't take their meds, and they're in and out of the psych hospital. And do you have to go to court every single time somebody's going to need to be in the hospital for a week to have their meds adjusted? And that can get really messy. And so my suggestion, if that is your situation, is that when you do your annual report, or maybe you even just do it by separate motion, you say, and you get your medical records to back this up, and you say, this is the situation, and this is likely going to require this type of medical intervention. And at least in Polk County, I think Judge Raines will go along with signing something that authorizes you limited authority to consent to inpatient care without having to come back to the court. It may be a limited if the doctor says, you know, and likely we can manage this, you know, get the medication managed within 7 to 10 days. If you would get permission to admit somebody to the psychiatric hospital for no more than 10 days without court approval, and then if it's going to take longer than that, you have to come back to court and get approval to do it. But we had several cases where that was just really, really problematic, and one of the cases I was working on, the parent was a judge in one of the rural counties. I'm like, we have to find a way to get around this so that people don't have to go to court. It just doesn't make sense to do it that way. And the statute's been changed since then, and I think that generally if you know what you're asking for, you can get it now. And then The other thing, if you do want to cut off a relationship, so you see this person is taking advantage, every time this person visits, my son gets upset, and you do want to interfere with that relationship, then you have to go to court and ask for permission to do it. Consent to sterilization is something that's been in there. This, a lot of you are not old enough to remember this, but back in the day when we had medical facilities, people didn't live at home that had serious mental health issues. They were sent somewhere else to live, and the first thing that would happen is they go, this person shouldn't have any kids, and that's what would happen, yeah. And then consenting to end-of-life decisions, you need special authority to do. So if the person has, at some time in the past, signed an advance directive or living will, same thing, then, and you can talk about, well, if they've already signed it, then maybe the judge will give you permission in the beginning, but if they've never signed anything like that, then generally you have to wait until there's an issue, and then you can ask the judge for permission to make end-of-life decisions. Annual reports, so after your initial report, then you're required to refile an annual report. There's a form available at the Iowa Supreme Court website. You know, it's not rocket science if you just read it. To me, the rocket science part of it is figuring out how to get it filed on EDMS. You know, like, so if you establish an account on EDMS, write down your password. And you know, spend time in there. And if you get tripped up, call the clerk of court. For the county, first off, always file in the right county, because changing the county, if you've done it wrong, is a pain in the backside. And then if you're having trouble figuring out how to file, because there's different, they kind of want you to say, well, what kind of document are you filing? And you pick a category first. And if you can't figure out what to do, call the clerk of court for the county. Oftentimes they're very helpful, and they can help you figure out how to attach your document there. And then when you file your annual reports, some judges don't look at them, it's obvious, but other judges do. And Judge Raines specifically is very adamant that you not just copy and paste the same report you filed last year. She's looking for something different. So even though your situation may not have changed, use different words. How much does it cost? Well, I'm not going to do this myself. How much does it cost to get a guardianship or conservatorship? This is an estimate that I just made up in my office of how much time, what's our process, who does it, and how much time does it take. So you can see there's a lot of little steps involved here. And what's not on this list is we contacted whoever for whatever information, and they didn't respond to us. And then we contacted whoever or whatever for this information, and they didn't respond to us. And then we contacted, you know, every time I reach out or one of my staff people reaches out, that's a billable, I mean, that's what we do is we sell our time. That costs you money for me to chase you for information. This presumes I didn't have to chase anybody for information. Everybody gave us the information we needed right away. And if you can look down here, you can see 6.1 attorney hours, 9.9 paralegal hours to get us through the first initial report. And you can go to the next page. So on average, the background check is going to be $15 per person. The petitioner's attorney, depending on what their hourly billable rate is, mine's a little bit high, is around $3,000. Respondent's attorney, maybe $1,000, usually, unless we're fighting. There's not as much work on the respondent's attorney's part because they don't have the larger role. You have the burden of proof. And you might be able to get that waived or paid at county expense. Always ask. If your person doesn't have if they're on Social Security disability and don't have any savings, then ask county attorney. Oh, if you have asked for the attorney to be appointed at county expense, you have to send a notice to the county attorney for that county letting them know, hey, we want the county to pay for this. Yes. Right, exactly. So in your petition, you put that you're asking for the attorney to be appointed at county expense. And then you send a notice to the county attorney that says, hey, there's a petition that's been filed and there's a hearing and we've asked the county to pay for it, so that the county attorney has an opportunity to come and say, no, he has assets they didn't tell you about, so, you know. So court visitor, whether or not you need one depends. Court costs. This is changing. So it used to be that when we get to the end, I'd file an order. My proposed order said this, thank you. My proposed order said you win, this is the person who's going to be the guardian, and this other thing you asked for you get, and this other thing you asked for, one order that covered all the issues that we were dealing with. What I'm seeing now is the judges are entering independent orders. So let's say I filed an application for a guardianship and a conservatorship. We have a case like that, and I got an order from the judge approving the guardianship, and I got an order from the judge approving the conservatorship. I don't really know what's happening, but it costs $10 per order that the judge issues. So in that case, there were 3 orders when there could have been 1. So that's triple revenue. I don't know if that's why they're doing it or what, but that's what I'm seeing. So $10 per order. There's some initial cost. I don't know what the initial guardianship cost is. Like the court cost might be $500 and then $10 per order on top of that. So total between $4,000 to $5,000 depending on you know, how expensive your attorney is and how much chasing there is to do and whether or not somebody's appointed at county expense. And this is for if nobody's fighting. So that's why I think it's really important for you all to be educated on how can I do this myself? Is there a way I can do this myself? It's not rocket science, but it is complicated. And it does take somebody who has the time and capability to learn the details of how to do it. At least, if all you have is a guardianship, once your guardianship is in place, you don't need the attorney to pay an attorney. We do them. I mean, if you just want to and you don't have the capacity, and some people just don't have the capacity to do it. But if I'm going to do an annual report for a guardianship, then you know that's my paralegal communicating with the guardian, probably maybe an hour's worth of time and preparing the report. So maybe an hour and a half's worth of time if everything goes really quickly for the paralegal time, and then it's going to be another at least half hour of my time to review that form to make sure that it's correct. And so that's going to be like, you know, maybe $300 to $500 depending on how much time it took to get it prepared that you wouldn't otherwise have to spend if you filled it out yourself and submitted it to EDMS, which I think, you know, is reasonable for most people to be able to do. Yeah. Yeah. I have 8 minutes. Okay. I think that was the end. So I really like to save time for questions. I'm open to guardianship, conservatorship questions. I'm also open to special needs planning questions, whatever it is you folks need to know about. Yes. So the question is the child living in your facility and the guardian is not cooperating? And it depends on in what way is the guardian not cooperating. Are they just not communicating, or are they doing things you don't want them to do, or are they not doing things you're asking them to do? Okay, so the guardian's non-responsive to your requests for contact. All right, so in Iowa, every person who is a protected person has to have an attorney. So your first thing would be to contact the attorney for the protected person and let them know that you are having difficulty with the guardian, because that's the quickest way to get that fixed. Another thing would be to contact the attorney that is of record representing the guardian and say, we're not getting response from your client. Is there something you can do to help this? Sometimes those parties resign. So if you've been appointed at court expense and everything's done, then you like file your withdrawal and go, okay, I'm out. You know, so there may not be one. So that's you can call the clerk of court for the county where the guardianship is and find out who the attorneys already are, and then contact an attorney and let them know what your problem is. And if that doesn't help solve your issue, then somebody's going to file a petition for the protected person saying he needs an attorney because the guardian's not doing what they're supposed to do. Yes. Yep. The question is, how do you get a substitute guardian? And the most efficient way to do that is on your annual report. On the annual report, there's a question that says, can you continue to serve as guardian and do you need any help? And so on that report, that's where you would put, I don't want to be the guardian anymore. And if you have somebody who's going to be a substitute guardian for you, put that information in there. And before you file your annual report, have the person who's going to be the new guardian file their background check. And then when you get your order approving your annual report, look on there to make sure that the judge appointed that other person and let you go, because sometimes they miss it. They, you know, if it's one of those rubber stamp judges, then no, the background check form is available on the Iowa Supreme Court website, and you file it on EDMS and pay $15. Yes. Yep. Okay. So there are two questions here. One is, what are the factors to consider when deciding when should I get the guardianship process started? And my suggestion for that would be early. You know, as early as you're able to get it started. That would be my suggestion there. I really don't think that, I think that's the most, if you think this person has decision-making impairment, and because you can always undo it, but it's difficult to get it started once things get complicated. And so the earlier and less complicated the situation is, the better. And then the next question is, how do you find attorneys that know how to do this? Is there a vetting process? And there really is not. You can go, the Iowa Bar Association has a find a lawyer thing, but there are lots of lawyers that put in there that they work in guardianship that they don't do very much guardianship work in. So probably, I hate to say this, but a Google search is, and then when you find an attorney that, you know, somebody pops up, go to their website and look and see, because if it's if guardianship work is part of their regular practice, they will have information about guardianships on their website. And it won't just list, you know, a laundry list of, you see these where I see these where I go in and I look at an attorney and I'll pull up an attorney and it says what their area of practice is, and there are 16 things there. You know, that doesn't mean I'm not allowed to say, and as attorneys, we're not allowed to say that because we specialize in anything, or that because I know a lot about this, it means that you don't know as much as I do or aren't as good as I am. We're not allowed to do that at all. But I would say that you can tell a lot about an attorney's commitment to their area of practice by looking through what's on their website. I don't know if how long ago was that? Yeah, I don't know. They keep changing what they do through the legal clinic there. I don't know if they're still doing that or not. Wonderful. So what she's saying, for those of you who couldn't hear, or for the video, is that Ask has on their website also a list of attorneys that they've sort of quasi-vetted that have expressed interest in this area. And I would say if an attorney has gone out on a limb and requested to be there, that probably they do work in that area.